very complex, typically transnational problems and issues that defy easy resolution through a single approach. For example, a single law in an individual country. And the other problem is that not only are the problems that we face in the 21st century sort of complex, but they're also very, very fast evolving. And of course, what we're witnessing now is what seems to be a breakdown in the conventional international rule-based order. And so in the if that's happening, then what can be done to either shore things up or come up with something better or what have you? So sustainable governance is all about coming up with those sorts of approaches that are resilient, that are capable of operating in this constantly changing, complex, transnational environment involving environmental, social, and economic challenges and problems that change every day. So it's all about harnessing the unique energies and capabilities of each of government, private sector, and civil society, while at the same time acknowledging that each of government, the private sector, and civil society have got significant limitations in what it is they do. And each of them uses a combination of rule instruments, be those laws or standards or integrity pacts or whatever, processes, institutions, and actors. Sometimes it involves a great deal of cooperation and collaboration among government, the private sector, and civil society, or just government and private sector, or just private sector and civil society, as the case might be. And sometimes there's more of a rivalrous check and balance sort of dynamic in place. Both are arguably necessary. That's what sustainable governance proposes, is that you need to have collaboration in some circumstances. You need to have government, private sector, and civil society stepping up to the plate. But you also need to have a certain amount of friction, a certain amount of disagreement, a certain amount of pushing to be better. And so you need both the collaboration and more of the rivalrous dynamic at play. Next slide, please. Just to let you know as well that we are constantly coming up with new sessions and talks, and there's an ongoing project concerning exploring the viability and feasibility of there being a global rule of law coalition as part of the response to the seeming deterioration and erosion of the rule of law and the international rules-based order. And so there will be more sessions on that, and there's more information on that available on the CSR Institute website. But you can see that there's a lot of other things that Toronto Metropolitan University does, and so I'm not going to spend any more time on that, other than to encourage you, if you're interested, to check into the sorts of things that are available on the CSR Institute website. Next slide, please. So we're really fortunate to have Noah Arshinov speaking to us today regarding a proposal that he and some colleagues have come up with concerning a possible supranational, that is to say, on top of governmental approach to ensuring compliance and conformity with international treaties pertaining to bribery and corruption. And he is a lawyer and consultant. He has founded and is the president of his own consultancy firm, ACT International. He's policy counsel with the Federation of Law Societies and has worked with a number of different intergovernmental bodies. He's certainly worked with Transparency International Canada as well, has had different roles there as well. And basically, focus of his work has been on how can we optimally address the issue of corruption and bribery? What sorts of things can we do to decrease bribery and corruption from taking place? So therefore, he's perfectly positioned to talk to us today about the particular proposal that he and his colleagues are working on, which is it possible? Would it be useful to have some sort of a supranational enforcement mechanism on top of the domestic, within the country, legal processes and government agencies and laws to address this issue? Next slide, please. This is just to let everybody know, because we do have people from around the world patching in for this session. Welcome to you all. Particular welcome to those of you who are patching in from other parts of the world outside of Canada, where you're in a different time zone. And special props to you for patching in probably outside of normal working hours to catch this session. For all of you, if you have a question or a comment, if you could email me, I will do my best to fold in your question or comment into the session itself. And that concludes my opening points here. So Noah, once again, thanks again for joining us here today. We've been talking, you and I have been talking, and I must say, just full disclosure, Noah and I are colleagues that worked together before on a variety of different things, but we were talking in advance of this session about how to best talk about this. And I was suggesting to Noah that a good place to start would be to just, if you can lay out your basic proposition that you're exploring in the paper, then what we'll do is we'll kind of rewind the tape. We'll go back and talk about what are these things, treaties, how do they work, and kind of work our way back up to a more detailed unpacking of the idea and possible challenges, opportunities, next steps, that sort of thing. So over to you, Noah.
All right, thank you very much, Kieran, again, and thank you to you and the TMU and the CSR Institute for inviting me to speak on this. I hope everyone who's online finds this topic as stimulating as I do, because I really do think it's a very interesting concept to try and figure out how to solve some of these issues around the world by thinking outside the box and a little differently than what we're used to. Let me start by maybe just defining kind of how I got to this idea in the first place and what was kind of the driving factor behind it. And I'll keep it fairly simple. The first one is that corruption, for the most part, is a transnational crime, right? It crosses borders, money moves across borders, business moves across borders. Very rarely do we see corruption in a strictly domestic lens. So it often involves multiple jurisdictions. If that's the case, it also requires a multilateral solution. Um, and the way that corruption has always been outlawed has been a requirement that countries make corruption or make paying bribes to foreign public officials a criminal offense. What that requires, though, is then domestic authorities to enforce their own domestic legislation. So it's a transnational act with a domestic solution, if you will. And that's I think the beginning of where we start to see the problems. The second part of the problem is that every single country in the world, I mean, aside from all the stuff we read in the headlines today, but every country in the world has some element of protectionism, nationalism, and their own economic interests at heart. That's just, I think, a strict reality. The reason for that is because pretty much every country on earth is in competition with each other, right? Canadian businesses compete against European businesses, compete against American businesses, etc. So governments want to promote their own businesses to succeed, right? That's generally in the benefit of any nation state. The problem with that is then it comes into conflict with corruption at some point. If a Canadian enterprise ends up paying bribes to secure a foreign contract, it's up to a Canadian law enforcement agency to go after the Canadian company. And so, if any of you paid attention to the SNC-Lavalin affair, I started thinking about this a lot as that affair was going on and as it was being resolved. There was a lot of stuff being said in the media, but we couldn't get past this element of there's some component of national economic interest at play, right? There's some element of we want to prosecute, but we also want to protect, right? There's a little bit of both. We want to hold them accountable, but we don't want to hold them so accountable that that there become issues with their own operations, that it costs jobs in certain regions of the country, etc. So how do we overcome that, right? And so this is where I think having a international dispute settlement mechanism, a little bit different than the WTO, but also taking the WTO as kind of an informative center to think about this comes into play. And I can go into it now, Karen, again, or maybe we should outline the treaty first so that I could kind of go through that.
You would just a small point, and let's not belabor it because it's not central to your thesis. But I would definitely not say that all corruption is transnational. You just have to take a look at countries in the South in particular, and domestic corruption, entirely domestic corruption between one individual and another individual, between a policeman and an individual, and so on and so forth, are entirely domestic. But again, I don't want to, belabor that point. But that's part of the problem is that it's cultural to engage in corruption in those countries. Everybody does it. It's, taken for granted that you cannot get a permit, a purely domestic permit to build a house or to build a factory without bribing someone. No international element to that whatsoever. So we'll leave that aside. I understand what you're focusing on are the transnational ones, and I don't disagree with you for a second that that is a huge problem and deserving of the treaties that we'll be talking about here in a second. So totally agree with that. Secondly, I think we need to kind of recognize that, yes, sovereignty, national sovereignty, protecting interests of a country is a problem in the sense of, really, should Canada have just prosecuted SNC-Lavalin and not even explored other techniques and not worried about any loss of jobs in Quebec? Should they have done that? Should they not have done that in a purely clean decision? They wouldn't have been thinking about loss of jobs or SNC-Lavalin disappearing, which of course it has, replaced by another corporation. But we'll leave that aside for now. But so your point is entirely valid that national sovereignty is a sort of a key factor here. But United States has played a very interesting role here, and they've taken a leadership role, an intergovernmental leadership role, which is unusual for United States to be the cooperative party, to be the party that says, hey guys, let's all have a treaty and we'll all agree to that treaty. Now, the reason why they did that was because they went ahead and created an extraterritorial law, the FCPA, in the first place, which is their equivalent of our law and India's law and so on. And then they discovered, once they created it, hey, we're making our corporations, American corporations, have to not be corrupt in all of their dealings, but we're looking around at French corporations and German corporations, and they're not having to do that. We need to have an international treaty so that everybody's doing what we're doing. So it was a remarkable example of where the United States actually showed leadership in creating a intergovernmental approach to things, as opposed to we're bigger than everybody else and we're just going to ram down whatever it is we want down our throat approach. I only mention that now because now we've got a new administration in the United States, and instead of there being leadership from the United States in the area of corruption, we're having a withdrawal of leadership. And in fact, almost goes so far as to say a support for corruption practices, an encouragement of corrupt practices. That's just an ad hominem comment by me. You don't have to buy that or not buy that. But I just thought I'd add in that little bit of color before we move over to, so what are these things, treaties, how do they work, and so on and so forth. So back over to you.
Okay, so I actually quite like that history because I find it really interesting and it colors a lot of how this has all taken place and evolved, right? So I'd actually go further in saying what the U.S. actually did by getting to the point of a treaty, right? So when they had the FCPA, they were the only country in the world that criminalized foreign bribery. That was it. They were the only country on planet
Yep.
Earth that criminalized it, meaning only American corporations could not pay bribes to foreign officials, right?
Yep.
So of course, as soon as you do that, you go, uh-oh, we need to level the playing field. So I would partly argue that in almost in an effort to promote their kind of economic nationalism,
Definitely.
um, they created actually a global criminal offense, right? So
Indeed.
corruption became a global criminal offense because of the US's, I would call it lobbying efforts.
Yeah,
Now, I consider that to actually be a good thing. I think that's
me too.
that's a very good evolution of business practices over time. But so what? Just to fast forward a little bit, what it ended up happening was, to me, the big moment was 1999, the signing of the OECD
OECD.
Anti-Bribery Convention, because you had essentially the U.S. and all the U.S.'s competitors, so essentially Western Europe, Canada, Australia, New Zealand, um, signing on to this convention, which says all these countries must criminalize foreign bribery. Right. In short, that's basically what it says. Um, and why that's important was because at the time, those countries making up the OECD Anti-Bribery Convention represented 80% of global trade. 80%. So a huge, huge number, right? Now, if you can ensure that 80% of the world, right, that is doing commerce globally does not engage in corrupt activity, you've made a massive leap forward in terms of, I don't like calling it eradicating corruption, but curbing corruption, and changing kind of the mentality of the way that business is done internationally. Um, so I think that was a huge success. Interestingly, I mean, I like your point about what's happened today, but just before we get to that, so from 1999, you had the OECD Anti-Bribery Convention. I think at the time it was about 33 members. Today it's up to about 46. So 46 member countries have signed on to that. But in 2005, that treaty, I would say, kind of led to the UN Convention Against Corruption, the UNCAC, which now is up to about 190 countries that have signed on to that. 190 countries, in other words, today have committed to criminalizing foreign bribery. Again, huge. Now that's commitment. That's not necessarily to say that it's been successful in terms of implementation, but there's been a global recognition that that practice, that criminal activity that the U.S. first described, should be the same across the board. Every country should, in their domestic law, criminalize foreign bribery. So again, I think a very positive evolution. What I think is taking place now, and this I think goes to a little bit of the point that I'm trying to make with this paper, is that um, the U.S. is, I don't know if they've totally flipped the script, but what they've done, it's a different form to me of economic nationalism, because
Mm,
one of the criticisms of their implementation of the FCPA for years and years has been that they primarily went after foreign companies who
mm,
engaged in bribery, right? So
mm.
that there was some connection to the United States, whether they transacted US dollars or they had operations in the States, whatever it was. I think it was something like 65, 70% of companies that have been charged under the FCPA in the US have actually been foreign companies, not
Yes.
necessarily US companies. And so now, with the kind of new direction of what the FCPA is meant to be or become, which is a little bit confusing, but the one thing that to me comes out
Hmm.
of it is a clear
Yes.
a clear statement saying we're going to focus primarily on
Yeah.
foreign companies that
Yeah. Yeah.
engage in
Yeah.
bribery. So it's kind
Exactly.
of like they've taken what they've been always doing in practice and just formalizing it.
Yeah.
So anyway, it's an interesting kind of evolution of economic nationalism. But
Well,
that's
just
a
just before you go any further on that, so you've got the OECD treaty, and to use academic language, policy convergence. After that happened, the UN treaty took place. Now you've got all these countries that have at least signed on. Whether or not they've ratified and implemented it fully is another matter. But just technically speaking, excuse me, at a mechanical standpoint, what we're talking about is Canada having the capability to bring a prosecution against a Canadian company operating in India, and India not objecting to that sort of intrusion into their national sovereignty by bringing an enforcement action concerning an activity taking place on the territory of India. They're not objecting to that. And the reason why they're not objecting to that is because India and Canada and all the other countries agreed that this is an international crime anywhere it takes place. And India has got the same capability to bring a prosecution against a Indian company operating in Canada that engages in bribery and corruption. And Canada will stand back and say, hey, you've got the full right to do that. So that's just a little bit of additional color in that. Now, the United States has been by far the most aggressive enforcer of their domestic law, which is supposed to be a sort of a carrying out of the international treaties by far. aggressive, huge fines, and so on. Everybody has been looking to the United States for that sort of leadership. And perhaps that leadership will continue now, but it'll just be exclusively focusing on non-American corporations, and they will completely give a pass to any American corporation that does the same thing. And so that represents arguably uh, a withdrawal by United States from their previous role. But because all the other countries in the world have signed on to these international treaties, it means that they have got a capacity which they didn't back in 1999. They have got a capacity to bring their own enforcement actions against their corporations wherever it is they operate. So the backdrop has changed. It used to be just the United States and nobody else. Then it was the United States being very, very aggressive and dominating, and other countries, maybe the UK being a good example, kind of picking up the slack over time. Canada being dragging in their feet a little bit to this day. That's why Transparency International Canada is always kind of nipping at the heels of Canada, the government of Canada, saying more. Where's the enforcement capacity, and so on and so forth. But I just wanted to give that little bit of color into where we are today, and hence the space of the supranational mechanism as an addition to the ability that now virtually every country in the world has to just simply bring an enforcement action themselves, since they have that capacity to do that in an intergovernmental forum.
So to pick up on that, I mean, the key word that you mentioned there is capacity, right? And I think that's where this idea that I've kind of stems from. It's true, all these countries now have laws, right? They have laws that make it illegal to engage in corrupt activity. Whether they actually truly have the capacity to prosecute, though, is one of the big kind of red flags of whether the implementation of these treaties is going to be successful. Um, just very briefly, what's involved in a prosecution, right? First, you have an investigation. If we're talking about transnational corruption, yeah, Canada and India might agree that corruption is an offense. That doesn't necessarily mean that those two countries are going to cooperate with each other to share evidence and everything else that's required to basically make a case, right? Um, so you need then, you need MLATs, mutual legal assistance treaties. There's all kinds of things that go on in order to have a successful prosecution, and then you have to actually get to the point where you have to prove the case, right? So then you have to go through the whole thing, hope that you have the correct evidence, and that's where we have found. I'll leave the U.S. aside, but in most other countries, kind of a failing to enforce uh, corruption crimes because they're so complex to investigate, they're so difficult to prosecute that we very rarely end up at a conviction. Very rarely. So Canada, I think, since from 1999 to today, we have I think it's 9 cases. We're up to 9 cases. Um, that's not very many, right? Like that's little, and the OECD has said that repeatedly in two successive evaluations. They've said, you know, for the economic profile that Canada has, for the industries that tend to dominate in Canada, for the fact that we have a very international economy, it just does not seem reasonable that there are only 9 cases of corruption that have taken place, right? Like it doesn't quite add up. So where do we go from there?
Oh, hold on. Just
Yeah.
before you go further, just to point out, and at the end of the day, OECD can do nothing other than what they're doing now, which is very sophisticated, to come up with this peer review process, basically a kind of a shaming technique to extol Canada or the Netherlands or whomever to do more enforcement, but also creates this kind of center of excellence in terms of sharing of ideas about how to better handle this thing or that thing, and peer pressure and all that, which is really great. But it also shows the limitations of supranational entities. They can't do anything that hasn't been um, uh, specifically allowed to them as a consent by a country saying you have the authority to do whatever it is that you do. So they only exist because of the consent of the participating countries involved. Second point is it's not just about crimes. As the United States shows, you can have a civil stream, and a civil stream is still not an easy stream, but a civil stream involves, for example, a balance of probability standard instead of a beyond a reasonable doubt standard. And potentially it doesn't involve requirement of proof of intent. And that has proven to be a highly useful other technique that has emerged over time. So I don't want to belabor those points, but I just want to kind of, again, flesh it out to say that that this is the operating environment. It isn't just about crimes. Crimes are central. And then you have things like the failure to prevent offense. That's a new innovation which tries to get around some of these challenges associated with having to prove intent for corruption situations. So Canada doesn't have that, but Transparency International Canada has proposed that we do have it. The UK has it, Australia has it, and arguably that's another thing that's happening in this evolving space. Sorry, over to you.
No, absolutely. I completely agree with you. And I mean, that is the main difficulty with international organizations kind of leading the way on, the future of any of these systems. That said, though, so that's why I'm going to go back to my this paper that I wrote, because the reason I started with the OECD is that I don't think you could do something like this under the UN. I think there's too many non-like-minded countries. It's a bit too chaotic of an atmosphere. Whereas the OECD, again, it's largely made up of the world's wealthy democracies, if you will, right? Generally like-minded nations. So if anywhere you could create or build on a system of like-minded countries who already, again, were the first ones to agree to essentially create a new offense globally. I think that's the place to start. And so, but you're absolutely right. You need consensus, and that's an enormous hurdle that I truthfully don't know that it could ever be overcome. But that's the place I would start. Um, and so the, the that's the second issue of why I think we need to go beyond relying on domestic enforcement authorities, right? Canada has 9 cases, and if you look at the entire history of all the OECD countries and their enforcement of corruption, that's not actually that bad. Like I think that still lies in the top 10 or 12, which is kind of tells you how difficult it is to enforce this stuff in most countries. Every country has their own legal system, legal norms, etc. Um, but when you leave it to domestic authorities to enforce these very, very, very complicated, complex, transnational offenses, it just becomes, I think, overly. I don't know if it's overly cumbersome or too onerous, or just they might not be able to allocate the right resources in order to do it because there's other crimes you have to prosecute. And so it takes a lot for domestic authorities to be able to go after corruption offenses. Um, but the second part of that then is okay. So let's just use the SNC-Lavalin affair as an example. Okay, so let's say Canada did not uphold their obligations under the OECD convention. Just for the sake of the argument, right? Let's say they didn't. Let's say they didn't go forward and fully prosecute them to the full extent that they could have. If you're any of the other signatory countries to the OECD convention and you look at that, all right, and you say, well, hang on a second. If Canada's going to get away with this for one of their big, large entities, right, and they're not going to throw the book at that company when really the corruption was egregious. It was a decade long. There's tons of evidence that it took place. Why should we're Germany? Why should we prosecute our German nationals to the full extent? Why shouldn't we also give them some form of protectionism? Well, how about this instead then? How about Germany would be able to bring a complaint against either the private entity, SNC-Lavalin, or the country enforcing the convention to some other body, right? So that's where the kind of concept of an OECD dispute settlement mechanism comes into play. You then would have Germany or Switzerland or whoever saying, hold on a second there, Canada. you're not adhering to your obligations under the treaty, right? You have this case, you haven't done everything you should do in regards to that case. Um, so we are going to file a complaint within this kind of dispute mechanism. Um, and maybe that's a way to increase the accountability of each country that's supposed to enforce it.
Just one thing, just one
Yes,
thing on that. I think you really need to talk very briefly, at least, about the World Bank.
absolutely. So I can go back into that because that's I think the World Bank and the multilateral development banks are, to me, they're a separate potential mechanism, different than the OECD. And actually, what I'll do, I think I can share my
Yeah,
screen very
you
quickly, because
should have that. Yeah.
okay,
If
let
you
me just
don't,
try
we
this.
can arrange that.
Okay, here I'm gonna share this because this is, whoa, my screen went all over the place. Okay, I think it's up there.
Yeah.
This is a colleague of mine that wrote kind of an idea in parallel to the one that I have about the OECD, but about the multilateral development banks and their role that they can play um, as well in this. And um, the reason behind this is that the multilateral development banks already have a certain system to sanction companies that engage in kind of in corrupt activity. And what that means is basically that any of those companies that are found to have engaged in corrupt activity, or what they're called prohibited practices under the multilateral development banks, will not be able to win contracts from the World Bank, the Asian Development Bank, the African Development Bank, the Inter-American Development Bank, Islamic Development Bank, and now there's the Asian Infrastructure Bank. So any of those entities, they won't be able to win contracts. If you are building infrastructure pretty much in any developing country on planet Earth, and you can't win a contract from that is financed by one of the MDBs,
Kiss of
that
death.
yeah,
Yeah.
that basically means you're not doing business in those countries, right?
Right.
So it is a huge, huge sanction. So what she wrote essentially was that what if MDBs were the launch pad for a global anti-corruption court? So in other words, they were, instead of looking at the idea of an international court, look at the MDB system to begin with, right? Um, so instead of a universal treaty, you start with a targeted pilot, right? A niche integrity ecosystem that already shares legal definitions, standards, and case procedures. And that ecosystem is what she argues already exists, right? This is the current sanctioning system of the MDBs.
Yeah.
And just for the sake of people on the line that are not as familiar with this, if you're excluded from contracting with the World Bank, this is what's called a cross debarment mechanism. So if the World Bank says, sorry, you've engaged in prohibited practices, you can't work on, you can't win any of our finance contracts, that applies to all the multilateral development banks. So the cross debarment means you're also excluded from any contracts from the other MDBs. So again, it's a huge sanction.
Yep.
Um, so she basically argues that, okay, what if the MDBs then had their own kind of common appellate sanctioning body? Um, Whereas right now they have their procedures, they all have their own kind of procedures. They've all agreed that if you get to the point where a company is excluded from contracting, that they will all recognize that decision, but they all have their own procedures. So what if now, if you actually just, it all filtered into kind of one common appellate body system? I quite like this because it's not reinventing the wheel. It's something that generally currently exists. Um, but again, there are some politics that you have to overcome, similar to what you'd have to overcome in a new kind of OECD dispute mechanism. Um, but I think it's an interesting concept, and to me, I think these two would go hand in hand, right?
Indeed.
You'd have two versions of the same thing. One is the body that provides the financing that basically says, nope, you're no longer eligible to get financing for your infrastructure project. The other one is the one looking at uh, in like proper domestic enforcement of the obligations you've signed onto under a treaty, right? And either imposing some form of real sanctions on the country that is the signatory, or on the private entity that is domiciled in one of those signatory countries.
This just parenthetically, this reminds me of the Equator Principles, which was a way in which financial institutions got together and ultimately agreed on a set of principles pertaining to lending practices that the lending is supposed to take into account environmental, social, economic implications of what's being done, and ultimately that being to some extent or another standardized. And so I view both your proposal, the existing capability of the World Bank and IFC and all of the other ones, their current practices right now. For example, SNC-Lavalin, the big immediate sanction they got was from the World Bank
Yep.
IFC, and it was a big one. It was a really big one, and they, were very much, desperate to get out from under that as soon as possible. And of course, the world is still benefiting from the money that Siemens is distributing out of a settlement that they reached with the World Bank. So what I see you proposing is you're kind of looking to the future. You're looking to a more multilateral world than we have now. You're looking to the next stages of that multilateral evolution, which would be moving from independent individual action by country X, that's US originally, to it being multiple countries, that being the treaties, through to it being the World Bank and the others individually addressing this issue, through to the possibility of them getting together and saying, let's agree on this process that we're going to individually apply whenever we are dealing with a possible, disbarment issue over bribery and corruption, through to them saying, let's just have one entity for resolving all this. Similarly, the OECD. So you're kind of sketching out a future world where there's more multilateral entities in place and not so much just individual ad hoc, non-systematic approaches to addressing the issue. So in that regard, yes, I definitely would agree with you. Essentially, the banks represent the follow the money approach to it. Companies that say, well, why should I care one way or the other whether or not you're going to do this or that to me? Well, you should care because you're not going to get any business. Okay, now you have our attention. Now you have our attention, right? So it's pressing on the follow the money lever, which obviously is an extremely significant lever to any company around the world. And so they're going to listen very carefully. If World Bank says that's not allowed, okay, we'll do this or that so that we're not going to be debarred from getting that contract. So yes, definitely these two things are potential things in the future that could emerge. Multilateral approaches and indeed multilateral approaches that ultimately glue together all of the development banks and the OECD and other treaty parties to agree on that. In the future, that could emerge. Definitely.
Yeah, well, I think we're in an interesting point in time because, yeah, in the future, again, you need consensus, right? So,
Well, yeah, it's not consensus, it's consent. It's just
yeah,
consent. Individual countries consenting, their individual sovereignty. They're giving up their sovereignty to decide this issue exclusively by themselves, and they're at allowing some other entity to actually be making a decision concerning something happening either within their country or to companies that are registered within their country. So it's consent, not so much consensual, but definitely this is the issue. But let's talk about another issue here, and that is the misuse of corruption offenses. So the best example of that would be, for example, China or Russia, where it's used there as a way of punishing quote unquote deemed enemies of the state. Suddenly we don't like American corporations, says China, so we're going to bring corruption offenses against them. We could be bringing them against our own companies, but no, let's just bring them against foreign companies that are operating in China, for example. Now, that issue, the politicization over the decision as to who is prosecuted, how are you going to get around the immediate perception of Sweden brings to the attention of this new supranational entity that Canada is doing this horrible thing? So Canada then says, well, I guess what we're going to do is we're going to withdraw our something or other from Sweden. So we're going to retaliate. How dare you select? What about all the others? The whataboutism that will immediately take place. How are you going to create a supranational entity that will be above reproach in terms of why are you going against Canada? Canada is not the most serious offender in this area. It's so and so. Why aren't you going against them? So what sorts of techniques have you thought of that would be insulating this supranational entity from the accusations, real or imagined, that it's actually selective enforcement engaged in by this new supranational entity?
It's a great question. I don't know if I have a perfect response, truthfully, because I think that is absolutely one of the risks. What I would say though, and what I tried to draw inspiration from in this is looking at different trade agreements that exist, and for all the pitfalls that the World Trade Organization has and everything it's gone through, there's also a lot of upside to that to how it was designed, right? So, for example, um, just the concept of having an independent panel at each time be struck to hear a complaint, and that independent panel must be made up of a roster of constituents that are not from either the complainant
Mhm.
country or the respondent country, right?
Yep.
Like that alone should be a potential way to limit the kind of politicization of things, right? Now, how you select who's on the panel, those are all things that you have to work out. That stuff can be quite difficult. Um, and then, the other issue that the World Trade Organization has had is their appellate body system. So I don't think I would follow the same way that
No,
they've designed the appellate body system. But again, these are lessons that we've learned internationally, right? We've learned this through the
exactly.
multilateral system, and
Exactly.
we're at a point where we can try and make improvements. I don't think we're ever going to get this stuff perfect, right? It's
No,
always it's always living. It always requires adaptation and evolution. But I do think that we've tried a lot of things in the multilateral system over the years that have been very good ideas. Some that have worked maybe 75% to the extent that they were supposed to work. But that's great. Let's take that 75% and try and improve on it,
sure,
right? Let's try and get that
sure.
up to 90. And if we can do that through a new kind of system, um, that's great. I mean, part of this is also it's a little bit trial and error, right? So
Yeah,
Sweden makes the complaint at the OECD about Canada's lack of enforcement. Okay, so they say, look, there's ample evidence to show. And sorry, I'm picking on SNC-Lavalin. I don't mean to be, but it's a good example, right? So there's ample evidence to show that SNC-Lavalin engaged in all kinds of corruption. We don't think Canada is upholding their obligations under the treaty. Therefore, we're issuing a complaint to a panel. We want a panel to be struck. We want to hear the arguments for both sides. Okay. The panel, though, has to be empowered to make a decision, right? I think you said this previously. Currently, there's no sanction ability of these kind of international organizations. Take the MDBs aside because they can withhold funding, right? That's huge. But the OECD can't really do anything other than name and shame right now, which has so far actually worked fairly well. Um, so you need to empower them with some kind of sanctionable ability. Now, what could that be? That's kind of difficult because it could be things like you know adding a percentage penalty to what the country pays into to be a member of the OECD in the first place, right? So that is a potential financial penalty. It could be increased monitoring, right? You could be subject to increased monitoring, the entire country, right? The efforts that go into responding to the OECD evaluations on their implementation of the anti-bribery convention are enormous. If you have to double down on that and do extra, that is a massive undertaking that I don't think any country wants to do because it's resource intensive. It requires you to examine all your legislation. It requires you to examine all the implementation of that legislation. It's a very big undertaking. So it's a potential sanction that could work. Um, but I think that those are elements that have to be built into that system.
yeah. I mean, the big challenge, however, and I give full props to the OECD in the sense of I think they have done everything they can to create supranational mechanisms to goad, encourage, incentivize uh, participating signatory states to comply. There's that. There's also the NCP process, the associated with the OECD multinational enterprise guidelines, or what they're currently called now. And again, I think those are very, very sophisticated incremental moves by the OECD to create some degree of supranational accountability for what is otherwise purely state activity. Just to point out, though, if they're having that much difficulty just doing these evaluations, and that requiring a great deal of effort, imagine the amount of effort required to collect the evidence that would be needed to do that, to create a roster of individuals who are agreed to carry out the actual adjudication function, to house them. I'm definitely seeing a new building in the Netherlands, envisaging this in the future, and OECD kind of drooling at the mouth about the possibility of, yes, a new thing with OECD at the, and bright lights at the top of it, because they've got their own empire building that they're involved in as well. So all of this is to say that why I really wanted to have you on here and to commend you and your colleagues for putting this out here. This is how we get progress, is by putting up a trial balloon and saying, we know these are the limitations, but we know that these are the strengths. And if we don't have something on the horizon that potentially we're working our way towards, then we will not currently construct and design into our current regimes an opportunity for this to happen. And it's in that regard, I want to just, the final point over to you. What sorts of changes would you see are necessary? Just small changes in, for example, the language of the OECD treaty or the equivalent UN treaty that would create a doorway for this to happen. Just a doorway. Yeah, go ahead.
Yeah, I think one of them is so they're at a point, the OECD is at a point where the original convention had 4 phases of monitoring, right? And phase 4 is almost complete. And so they're currently in the stages of negotiating what will phase 5 of monitoring actually look like. I think this is an absolutely perfect time to think about some of this stuff, right? So phase 5 of monitoring should look at, okay, we've looked at everything that is required under the convention now. We've analyzed it, we've evaluated it, we've given the feedback back to every country. Okay. Now it's about, have you truly implemented everything to the extent that you're supposed to? And so partly I think through phase 5 monitoring is I think it should be made a little bit more mandatory, right? Some of the recommendations that come out of phase 5 should be made not so much recommendations. They should be mandatory obligations for your kind of further continuance as part of this convention. And I think those little incremental changes, if we start just by changing that language a little bit to make it seem less like a nice to have and more of a must have, we'll get to this point where you can use, whether it's the OECD or some other body, where kind of countries can kind of hold each other accountable. That's where I think we'll get to. But I think those little changes, the easiest way to do it is in the next phase of monitoring, because it doesn't require an immediate change to the language of the convention itself. But I think it can lead to those incremental changes into the convention language itself, because the convention now is getting kind of old, right? It hasn't changed really at all since 1999, with the exception of the big 2021 recommendation. But yeah, I'd say that's probably the next step. Is really I'm hopeful that what comes out of what phase 5 will be a change in that kind of language of, now you've had plenty of time, right? Now it's no longer time to like put in place all the measures you need to put in place. Now it's time to look at action.
Well, I think you're being modest in your incremental change. Something that strikes me as something that could be proposed would be that there must be a mandatory review of any treaty every 10 years. obviously that's a replication of something that exists in many countries with respect to legislation, but that creates this opportunity for review that can't be got around because it's built into the treaty itself, into the language of the treaty itself. And I would think that sort of opportunity then is an opportunity to add in actual language in the treaty, which would just say the OECD has the authority, with the consent of the signatories, to explore other mechanisms and approaches to ensure compliance with the treaty. Just something open-ended, no mention whatsoever about an actual supranational enforcement agency, but just providing actual language there that can be turned to by, Noah Arshinov, or by the government of Canada, or whomever, government of Sweden, saying, I think it's time now. Somebody should write a paper exploring what exactly that would look like, or whatever. So I'd just be a
Yeah.
little bit more ambitious. You're being modest by just saying we need to up the game and make monitoring mandatory. Sure, that's like a low hanging fruit, but definitely we can start with that for sure.
Yeah, overly realistic, perhaps. Maybe I do need to be
Perhaps.
a bit more ambitiously idealistic.
Well, at the same time, you're being ambitiously, unrealistic by suggesting that there be a supranational entity. You know that's not going to happen. So you're playing both sides of the fence at the same time, which is not a bad strategy. I encourage you to keep on doing that.
Shoot for the stars, settle for the moon, right?
Indeed, absolutely. No, it's always a pleasure talking to you. And I want to thank you on behalf of TMU, Toronto Metropolitan University, and more specifically, the Institute for, first of all, for you taking the time to create the paper in the first place. Full marks to you and your colleagues for getting the ideas out there. And then secondly, for coming in for this session. And hopefully we can do another session in the future.
Sounds great. Thank you very much, Kernan. Appreciate
Thanks.
it.
All the best. Thanks, everybody, for patching in. I tried to fold in your questions and comments as well and appreciated them. All the best. Have a great weekend, everybody. Bye now.